Part 2 of WPSD's Local 6 Legal Line, and it's Joe Roark of the Bryant Law Center answering your questions regarding divorce at 1-888-208-6946. We have a question from Lisa who says, I bought my house before we got married. So if I get divorced now, will my husband get half of it?
Well, if you bought it before you got married and it's fully paid for, then you have a non-marital claim to that because you owned it prior to your marriage. If you bought it and say you just had the deed, but then you continued to make payments on it after you were married, say it wasn't fully paid for, then it is a mixed asset that has both a marital and a non-marital component, and your husband probably would be entitled to an equitable portion of whatever was paid down, the principal only, during the course of your marriage.
Parker has a question, and he says, is it really a good idea that I use the same attorney for divorce as my wife?
Well, you can use the same attorney. Understand that attorney does not represent both of you, Parker. So I mean, it's not a scenario where that one attorney represents you both. They represent one person. And if all that is happening is that they are memorializing the agreement that you guys have already reached, that's fine. But it's never a bad idea to let somebody who represents you and has an ethical and professional obligation to make sure that this deal is appropriate and fair for you, looks at it on your behalf. It's never a bad idea to do that, but you don't have to.
We have a question from an anonymous viewer who says, I was divorced 15 years ago and did not know about the 50-50 custody law. Can I do anything about it now?
Yeah, the custody and time sharing are always modifiable on down the line, and the 50-50 law has to do with the time sharing component of it. So if there are circumstances over and above just the enactment of the law, then you can move to modify your time sharing to see if you can get a 50-50 arrangement. The law says that there is a presumption now that that is the appropriate time sharing arrangement, but just the passage of the law itself is not enough to justify modifying your time sharing arrangement. There has to be something in addition to it that would otherwise justify a change. Just you don't get a modification just because there was a new law passed. Appellate courts in Kentucky have made that determination, and so you probably after 15 years are probably entitled to at least have another look at it, but you can certainly move for it to be modified, and that may be the standard that would be applied.
Got a little bit more than a minute left of this segment, and we have a question from Amber who says, I'm separated from my husband. It's probably headed for divorce. So how can I be sure that he's not out running up a lot of credit card expense in my name?
Okay. That happens a lot, unfortunately, and so one thing you can do always is get a copy of your credit report. You're entitled to one free copy of your main credit reports each year, and so you can get that to know if there are new accounts that have been opened under your name, if there are any accounts that carry a balance that are in your name. The other thing you can do, if you have already gotten that or you don't have access to it, is there are lots of services you can sign up for, paid services, where you can check your credit and know if there are things that are being done. But if you don't have access to credit cards on which you are a card holder or that you're responsible for, you should probably go ahead and try and find a way to get copies of those statements and make sure that that's not something that's happening, and that you're not protected until such time probably as there's an action or a separation that takes place. So don't be put on the hook for credit card expenses from your soon-to-be ex-spouse.
Our thanks to Joe Roark of the Bryant Law Center for his expertise today in the world of divorce.